During today's session of Legal History Storytime, we will be discussing the case of Island Trees School District versus Pico. This is a landmark case regarding the school board's ability to censor school materials. The story starts out in the year 1975 at the Island Trees School District in New York. Students had access to all sorts of books. However, some parents found out what books were available and got very upset. These 9 books are un-Christian, un-American, and just plain filthy. We will not allow them to be around our children, the parents yelled. The school was not happy that the parents were so upset. Okay, said the school. We'll remove some of the books you don't like, but please stop making such a fuss. And the school removed 7 of the 9 books that the parents didn't like. However, a student named Stephen Pico chimed in. Hey, District Court, isn't it against our First Amendment right for the school to censor the books we have access to? No, said the District Court. Schools have the right to do what they want, including select or remove books. I still think that's unfair, said Pico, so he appealed and got the decision reversed. This back and forth meant that no one was able to reach a final decision and everyone had questions. Schools inevitably make decisions about which books to include in a curriculum. Is selecting what's appropriate or inappropriate for students considered censorship? And does the First Amendment even extend to protect students? There is a long history of court cases trying to decide exactly what these rights are. The Island Pico case therefore became quite a big deal. Maybe we'll solve the issues of censorship, the legal community thought, and we'll have a clear answer for our other questions about public school rights. For example, in 1965, students wanted to wear black armbands at school to protest the Vietnam War. The school did not like this activism and forbade the students. 13-year-old Mary Tinker refused, and eventually the Supreme Court got involved and ruled in favor of the students. Students do not shed their constitutional rights at the schoolhouse gates, the judge said, but we still won't protect vulgar speech or anything that causes a disruption, he quickly added to his decision. Students clearly have some protection under the First Amendment, but just how much was up for debate. Fast forward 13 years to the Island Trees versus Pico case. Everyone still wanted answers to how much protection was afforded to students. Maybe this case will provide a clear decision, everyone thought, as they waited on the edge of their seats for the results. Out of the 9 justices presiding over the case, 4 said that the First Amendment provided students with protection from censorship, and 4 said that the school had the right to choose and remove materials. It all came down to this last justice's decision. How would he break the tie? Eventually, the last judge stood up. I have made my decision, he said to the hushed room. I side with Pico overall, but I will not get involved in this debate over First Amendment rights and refuse to include any discussion of the First Amendment in my official decision. The judge continued, the school will remain in charge of curriculum choice and will be allowed the power to select books they consider educationally appropriate, but they can't just remove books because they contain political or social protections that the schools disagree with. The legal community turned to each other as the courtroom emptied. What books count as educationally appropriate, and who decides what the motives for the school are? Did the judge actually just give schools more censoring power even though he sided with Pico? People often cite this court case as a win for anti-censorship, but Justice White's refusal to agree that the First Amendment is the reason for this decision leaves everyone in a tricky spot. In the end, the ruling regarding the First Amendment was stuck in a 4-4 tie because Justice White chose not to weigh in. This battle over who has the rights to control what students access is far from over. A more recent censorship battle has been over CIPA, or the Children's Internet Protection Act. This act requires any libraries taking advantage of federal E-rate discounts to also install software that filters obscene material. In 2001, the ALA challenged CIPA in court, stating that it worsens digital divide and limits patrons' First Amendment rights. These filters often remove more than is necessary by law and can be difficult to disable in the instances when disabling them is allowed. However, the court did not agree with this decision, and CIPA still exists in law. Legally, adult patrons can ask librarians to unblock sites, no questions asked, but patrons are often not aware of this or may feel too awkward to ask. CIPA clearly remains an issue for many librarians. At the heart of these issues is the question of what counts as selection and what counts as censorship. A library or school's right to choose what information to include in a collection versus the suppression of information that is deemed offensive. The difference between these terms is highly subjective. What one person sees as selection, the next person views as censorship. As demonstrated in how many times the Island Pico decision got reversed, it is easy for either side of this fight to feel justified legally. As library and information professionals, we must be aware of these ongoing debates and think long and hard about their ethics. As the court's decisions have shown, there are no easy answers or one-size-fits-all solutions to questions of selection and censorship.